We're going to hit on 4 or 5 different topics, and then I'm going to try to leave some room for questions at the end. So if y'all have other topics you want to talk about, I'm glad to do that as well. I have to give a little disclaimer when I speak. It basically says I'm a lawyer. I'm not your lawyer. So I'm going to give you general information. I can't give anybody specific legal advice. So with that, here's a few resources I've got related to ag law. So if this is a topic you're interested in, here's just some information that we've got. I've got a handbook that I wrote. It's called Owning Your Piece of Texas. Basically, it's just an overview of kind of the top 13 or 14 ag law issues for farmers, ranchers, rural landowners. If anybody's interested in that, you can go find it on my blog, and I'm going to give you the website for that in just a second. You can get a free PDF of it there. If you want to buy a hard copy, we sell those because we have to pay for printing and shipping. And you can call my assistant. That's her phone number. So if anybody's interested in that handbook, you can find it. Like I say, it's free online if anybody wants a copy of that. Here's where you can find it. This is my blog. So basically a blog is just a website, right, where I post ag law information. So when a new case comes out, I post it here. When everything went crazy with dicamba and we were trying to figure out what that Ninth Circuit opinion meant last year, it gets posted here. So if you're interested in that, that's the website, or you can just Google Texas Ag Law Blog, and it'll pop up there. I've also got a podcast, all right? So if you're a podcast listener, you can listen anywhere you do your podcasts. We're on, Stitcher and Google Play and all those places. If you're not a podcast listener, basically what it is, I interview an ag lawyer about a different topic every show. You can listen for free. It's just audio. If you want to listen on your computer, all you've got to do is go to that website, aglaw.libsyn.com. Type that in, and what you find is a list of 102 episodes where I've talked to people about different ag law topics. Just pick the topic you want and push play. You can listen to those for free. And with 102 episodes, we've kind of covered the gamut, right? We've done water law and fence law, and today's new one is on property tax exemptions. So if you're interested in that, check it out. Texas Corn Producers is one of our sponsors for the podcast. We appreciate that. They're here today. So if you're a podcast listener, let them know you appreciate their help and sponsor it. So with that, here's what we're going to talk about today. Here's kind of my list of hot topics I think is worth mentioning. The first one has to do with the Texas Farm Animal Liability Act. That's a statute that gives some limited liability to agriculture producers that have livestock. We'll talk about that in detail. We're going to talk about a case that deals with fence law that I think is really important. We'll mention that. We're going to then do what I call the dicamba debacle, and you guys live that. You know more about that than I do probably, but we'll talk about what happened last year and what's happening now with the over-the-top dicamba products. Then we're going to look at an issue with a solar lease. There's a recent case on that I think is really interesting. And then if we have time left, I've got what I call honorable mentions, just some other topics in the news that I'll at least tell you about and make you aware of. So we'll start off with the Farm Animal Liability Act. The Farm Animal Liability Act is a statute here in Texas that basically gives some liability protection to you if somebody is injured as a result of an accident with a farm animal. So it used to be called the Equine Act. The idea is there are certain inherent risks if you're engaging in a farm animal activity, right? If you crawl on a horse, there's an inherent risk you could get bucked off. Even if you don't do anything wrong, even if the horse owner doesn't do anything wrong, something could just happen. And so the Texas legislature recognized that and basically said, look, we don't think livestock and horse owners ought to be liable if somebody gets injured due to one of these inherent risks. And so they passed this statute, the Farm Animal Liability Act, and it basically says that. Okay, it says a person is not liable if an injury is caused by an inherent risk of a farm animal activity. So that's really good for livestock and horse owners, right? We don't have to worry if somebody gets injured on our property that we'll be liable. And this was passed back in the late 90s. So it's been around for a long time. There are several exceptions that exist, so it's not bulletproof, right? It's not this magic thing that always gets a case dismissed, but it's a good defense if you own livestock or horses. Here's how it works. Let me talk you through this case. This happened a couple of years ago. There was a family that went to a ranch owned by another family, and they were working cattle that day. Men worked cattle all day. The wives and the kids were in the house. At the end of the day, they had a bunch of horses tied up on the fence by the barn. Little kid who's 6 years old from the visiting family came out and said he wanted to ride a horse. So they pulled 2 horses off the fence, put the 6-year-old on one, put another kid on the other, tell them, ride to the end of the road, turn around and come back. Okay? So they ride to the end of the road, no problem. They turn around. What do you think happens? Barn sour horse, right? Takes off, goes home, and kid gets bucked off, or didn't get bucked off. He falls off, gets injured. So his parents, right, the parents of the injured kid sue the horse owner. And they say, you were negligent in letting our kid get on your horse. And so the horse owner raises this Farm Animal Liability Act as a defense, right? And basically he says, this is just what the act was designed for, right? Injury with the farm animal, it's an inherent risk. A horse could take off running. Judge dismissed the case. Okay? The parents relied on one of the exceptions to the act. And what the exception says is you can still be liable if you don't make a reasonable and prudent effort to determine the ability of the rider to safely manage the animal. So this is the question before the judge. Did these horse owners make a reasonable inquiry into that kid's ability before they put him on this horse? What do we think? We think it did? Why do we think it did? Who was standing there when he crawled on the horse? His mama. That's a bad fact for their lawyer, right? If mom is standing there, lets the kid get on the horse, doesn't say anything, that's not ideal, right, for their lawyer. The other fact is, turns out this kid's 6 years old. He owns his own horse, and he rides all the time at home. So we got a ranch kid, right? And so the court, in all those facts, the court dismisses the case, and the appellate court affirms. And so that's how the statute's designed to work, right? We got an inherent risk. You're not liable for that. Case dismissed. Okay? Now, I want to point out, though, if you change those facts a little bit, I think it's a different outcome, right? What if it's not a ranch kid? What if it's a kid from town? And what if his parents weren't there and they put this kid on a horse without permission? Then we might have a closer case, right? Then I think we have a different problem. So that's James versus Young. Then last year came this case from the Texas Supreme Court, and everybody kind of went, oh, crap, that's not what we thought the law said. So here's what happened in this case. Really bad situation. In Central Texas, we had a ranch employee get killed while he was supposed to be moving a bull from one pasture to another. So the ranch owner's not home. He's got this employee who's worked there for like 5 or 6 years, lives on the property. He calls him from town and says, hey, you need to move that bull from the corral to such and such pasture. Owner gets home, goes out to the barn, finds the ranch head dead in the corral. And it's from blunt force trauma. The autopsy says that the bull killed the ranch hen. Okay? The owner did not have workers' comp insurance. So this is a pitch for if you've got employees on your farm or your ranch, you need to think about workers' comp insurance. I don't know, it's an extra cost. Nobody wants to pay that, I know. But what it does is it prevents somebody from being able to go file a lawsuit. Workers' comp would take care of the damages if you had it. Okay, but this guy didn't have it. And so the family of the ranch hand files a lawsuit against the ranch owner for negligent training and hiring of this guy. Basically, they said, you should have taught him how to deal with this bull so that he wouldn't have gotten killed. All right? So the ranch owner raises our defense, right? He says, hey, Farm Animal Liability Act, right? When you're moving bulls, it's an inherent risk that something like this could happen, and judge, you should dismiss the case. Okay? The trial court judge dismissed it. The appellate court we're going to skip over because they got overturned. And then they end up at the Texas Supreme Court. All right? Last year, we get this opinion from the Texas Supreme Court in favor of the ranch hand. So they sided with the ranch hand's family, and what they said was, we don't think the Farm Animal Liability Act was designed to apply on working ranches. So the technical word they said was, if the injured party is a rancher or a ranch hand, this doesn't apply. So they thought it was limited, this is the Texas Supreme Court, it was limited the statute's protections to the contact of shows, rides, exhibitions, and competitions. We had never read that statute that way. And you can't read the statute that way because it doesn't say that. But that's how they interpreted it. right? And they basically said, okay, fine, if it's a horse show, if it's a steer show, if it's a trail ride, if it's a rodeo, the statute applies. But if you're just at your ranch, it doesn't come into play. So that was a decision from the Texas Supreme Court. There was a really strong dissent from 2 justices that basically said, hey, we're not here to rewrite a statute. It says any person is not liable. That's how we should read it. And if the legislature wants to change it, they can. But that was the minority, and so we have this rule right now where the Farm Animal Liability Act doesn't work for injured ranchers or ranch hands, okay? However, here's the update. The legislature is trying to fix it. So there's a bill in the House called House Bill 365 from Representative Muir. It essentially would modify the Farm Animal Liability Act to undo that decision in the Watt case. All right, so what it would do is it would expressly say it applies to farms and ranches, and it would describe some of the activities you would do and list them in there. So it already talks about, like, if you're riding a horse or if you're moving an animal. It would add stuff like it applies if you're vaccinating, branding, castrating, loading, unloading, all these things to just clarify that that's what the act is going to mean. So that's in there. It also says it applies to the engagement in routine or customary activities on a farm or ranch to handle or manage animals. So that's real broad, okay? The other thing it does, it says specifically if it's an injured employee or independent contractor, the statute would apply. Okay, now there's one change here I want you to be aware of. If this gets through, and right now it's through committee, it's in calendaring, everything I hear is that they're hopeful this will get passed in Austin. If it does, here's the kicker. If you are a farm or a ranch, to get this protection, you're going to have to hang up a sign. And that's different. Used to, only people like veterinarians or horse trainers had to have a sign. If this bill passes, you're going to get the protection, but farms and ranches are going to have to hang up one of those signs that basically says, I'm not liable under the Farm Animal Liability Act. You can buy them for like $4 from Farm Bureau. Okay, there's probably other groups that sell them. That's where I got mine. But just be aware, if this passes, you need to get one of those signs to hang it up so you get that protection. Okay? Any questions on the Farm Animal Liability Act? Okay, 2 other acts I want to mention. I'm just going to say the names. If you have people coming on your property for recreation or education, so hunters, people riding 4-wheelers, field days, anything like that, there are 2 more acts that protect you. The Texas Recreational Use Statute and the Texas Agritourism Act. Look those up. You can look them up on my blog. But if you've got people coming for recreation or education, there's extra protection there if you jump through some real simple hoops. So just be aware of that. Okay? Let's shift gears and talk about fence law. So real quick overview of Texas fence law, okay? Anytime you've got a fence law issue, you've got to start with, are we in an area that's open range or closed range, okay? Open range is also sometimes called fence out. And what it means is if I own animals, I don't have a duty to fence them in, right? It's my neighbor's duty to fence them out if he doesn't want them on his wheat field or cotton field or whatever, okay? That's open range. Closed range is the opposite. It's called fence in. And it says if I have livestock, it's my legal duty to fence them in, right? I got to build a fence and keep them in. So the question then in Texas is, well, what are we? Are we fence in or fence out? General rule, the statewide rule is we're open range, okay, which means we are a fence out state, which means if I don't want my neighbor's cows on me, it's on me to build that fence to keep them out. It's not on my neighbor. That's the starting place, all right? However, this is where it gets tricky. There are a couple of exceptions that actually make most of the state closed range, all right? So the rule is it's open range unless one of these 2 exceptions apply. The first exception is all state and U.S. highways are closed range, period. So you get cattle that get hit on a state or U.S. highway, it's closed range. You had a legal obligation to fence them in, and you can be liable if you knowingly permit them to run at large. Okay, we'll talk about some examples in just a second. That's state and U.S. highways. That's going to be like I-27 and Highway 82. That's not farm-to-market roads, okay? So that's how that exception works. And again, the rule is you're liable if you knowingly permit them to run at large. The other exception is a local stock law. And what that says is your county can have an election and the landowners can vote to make all or part of the county closed range, okay? Where this gets tricky is a lot of these were voted on back in like the 1920s, and you got to go digging for them in the records to find them. I think, Caitlin, am I right, that this county is open range? Okay, Crosby is open, which means no stock law in Crosby County. Floyd County, closed range. That means you do have to fence them in. You see where this is a real pain in the rear when we got even from county to county, the rules are different. Okay? So I want to just give you a couple of examples so you can sort of, here's how to investigate your stock law. The first thing I always tell people, go talk to your county agent. Because I've been harassing them to get this information from me, and hopefully they know the answer. Yours do. You're lucky, okay? You can also talk to your county attorney, county judge, county sheriff. Hopefully they've dealt with it and they know the answers, okay? But you kind of need to know because you need to know what your obligation is. All right, so let me give you just a couple of examples. We'll go through these quickly. I just want to show you how the law works on fence law. All right, there's a case called Gibbs versus Jackson in the Texas Supreme Court. And in that case, a driver hit a horse named Tiny, ironic name in this situation, hits this horse named Tiny who's standing on a farm-to-market road in a county with no stock law, okay? The evidence in court showed that the fence was in disrepair. It was terrible. This horse was out all the time. So the driver sues the horse owner, and the question for the court is the horse owner liable? So let's walk through it. The first thing we got to figure out is what's the standard? Are we open range or closed range? Open range, right? That's right. We said open range is what we assume unless, is there a local stock law? No, right? It says no local stock law. Was this on a state or U.S. highway? No, it was on a farm-to-market road. So this is open range like Crosby County, right? So we got a farm-to-market road situation. Horse gets hit in Crosby County. Is the owner of the horse liable, yes or no? No, right? He doesn't have any obligation to fence him in. I don't care if he didn't have a fence at all. He's not liable because there's no obligation to fence that horse in. All right, that's how that works in an open range county. Let's look at a closed range county. Here's a case called Evans versus Hendricks. Cattle were hit on a state highway in a county with no stock law. They were kept on the back part of the pasture, away from the highway. They had a lock and a chain on the gate. The landowner never knew the cattle were out. They'd never been out before. These are the kind of facts courts are going to look at, right? So our first question, are we open range or closed range? Closed, right? Because we're on a state highway. So any state highway, no matter where we are, is closed range. And the question a court's going to ask then is, looking at these facts, did that landowner knowingly permit those cattle to run at large? What do we think? No, right? There's no facts there that look bad on the landowner. So the court said he's not liable. Okay, so even in a closed range county, if cattle get out, you're not automatically liable. It becomes real factual to decide. Okay? Two more cases I want to do. This case, Weaver versus Brink, cattle are hit on I-45 in a county with no stock law. The cattle had previously been out 6 times in 15 years. The owner knew his fences failed during hard rains, knew there was a good chance the cattle would get out that day, but he didn't go check the fences. He got a call the night before the accident that his cows were out. He did not go put them in. I don't want this client, right? I'm saying no to this guy. All right, so what's our standard? We got cattle hit on I-45. Are we open range or closed range? Closed range. So the question is, did he knowingly permit those cattle to run at large? Yeah, the court said yes. Those facts were not good, right? He knew about him. He didn't go do anything. That's bad. So the court said there he is liable. All right, last case happened closer to home. Rodriguez versus Sandhill Cattle Company. A driver hits cattle on a farm-to-market road in a county with a stock law. All right, We have 5-weight cattle on wheat pasture that were behind an electric fence. They were hot wire broke, and they'd never been out before. All right, so let's walk through that one. Are we open range or closed range? Closed range, right? Because the county has a stock law. So the question is, did the owner permit those cattle to run at large? Notice it's different. Knowingly permit is kind of a harder standard to prove. Permit's a little lower. So did he permit those animals to run at large? What do we think? Everybody here says no. Let me tell you about this. Anytime I do this presentation close to the panhandle, no one is worried. If I get to Austin, the closer I get to Austin, the more people are like, yeah, they're liable, right? This electric fence, we never heard of a one-strand fence. That can't be, okay? This was in the panhandle. The court said not liable, and the case was dismissed. So that's sort of how the analysis works in a fence law case, okay? A case last year at the Supreme Court of Texas raised a really interesting question. The question is this: if we're in a closed-range county, right, that's that permit standard, that the owner permit those cattle to run at large, but we're on a state or U.S. highway in that county. Now, that's a knowingly permit standard. See how we got two different standards that both apply. I call it double closed range. So let's say we get cattle hit in Floyd County on a U.S. highway or a state highway. Which standard is the court going to apply? Does the plaintiff have to show we knowingly permitted the cattle to run at large, which is harder for the driver to prove? Or can they just show we permitted the cattle to run at large, which is easier? This has never come up before, which is amazing to me because there's a lot of closed-range counties with state and U.S. highways. But this was the question before the court. This case called Garcia versus Pruski, a vehicle hit a bull on a state highway in Wilson County. Okay, Wilson County does have a stock law. The owner had one cow out 8 years ago. The gate was latched, so he had his latch done. There was a lock there, but he didn't have it locked that day. Somebody was going to come later and work on something. So latched, but not locked, okay? There was no cattle guard, and the bull got out. The driver files a lawsuit, and he claims that they permitted and knowingly permitted that bull to run at large. Here's why this matters. The trial court said they don't have the facts to prove knowingly permit. We dismiss that. But the trial court said we think there's enough evidence here on the issue of permit that it's got to go to a jury. I disagree on that, but that's what the trial court said. So they said knowingly permit is out. Permit, we're going to let it go to a jury. And now it matters a lot which of those two standards applies, right? Because the owner of the bull is saying, if they can't prove knowingly permit, that's the standard that applies. This case is out. The driver says it was double closed range. We can choose to prove either one of those to let the case go forward. So that was the question at the Texas Supreme Court. And the Supreme Court sided with the bull owner. He said only that knowingly permit standard applies. So if we're in a Floyd County situation, closed range county, state or U.S. highway, the injured party has to prove knowingly permit, which is a good decision for a livestock owner. Okay? Here's where this case makes me antsy. At the Court of Appeals, they said, the Court of Appeals got it wrong, and they said that the permit standard was good enough, but they also said there was enough evidence to go to a jury on permit. Again, this has been overturned, so from a legal perspective, it doesn't matter. From a factual perspective, it makes me sweaty. Here's why. The court really relied on two facts when they were trying to decide, did he permit those cattle to run at large, or the bull to run at large? The first one was that gate wasn't locked. Why I don't like that is we don't have any legal obligation to lock our gates, right? So who cares if there's not a lock on the gate? And I don't know about you, but frankly, our locks are not to keep our cows in, right? It's to keep other people out. So I don't like that line of thought. The other thing they really hung on was that there was no cattle guard. Again, who cares, right? There's no legal obligation that says I have to have a cattle guard in front of my gate. But the court really hung on that, and I think that that's a good reminder that we can get screwy decisions out of court sometimes when we have judges, right, that don't wear boots. You know what I'm saying? So I think that's a little bit scary. Like I say, undone in this case because of the Supreme Court opinion, but that's something that I think should be concerning for landowners just in general. Okay, Let's talk through the dicamba debacle. Like I say, you guys live this. Dr. Dotre knows way more about the science of this than I do. But here's just sort of what happened on the legal perspective and what we're seeing now. Okay, just a timeline on the whole dicamba issue, right? And we're talking here about the over-the-top dicamba, right? The Extendamax, Ingenia, Tavium, those products, okay? Fexapan's the other one. In 2015, Monsanto started selling the seeds, right? The Extend seeds that allowed the over-the-top application of dicamba products. They did not start selling the corresponding pesticide with it. So essentially, they released the seeds. There were 2 growing seasons where you didn't have a pesticide you could legally apply over the top, right? And it wasn't until that 17 season when you could buy those 3 chemicals or 4 chemicals we talked about, okay? That's going to be important for some of the lawsuits in just a second. So what happens? Lawyers get involved, and everything goes south, right? So we see a bunch of lawsuits for the 2015 and 2016 growing season against Monsanto, against BASF, some of these companies. And basically what the lawsuit said was, listen, when you released those seeds and told people they were dicamba resistant, but you didn't release the chemical with them, you knew what people were going to do, right? You knew everybody was going to go get off-label dicamba, Liberty and whatever the other ones are, Banville, and spray those instead. And so this was part of your plan, right? They basically said there was a conspiracy between these companies. You should have known this was going to happen. They sue the companies. Now, the companies basically say, wait a minute, we don't make the pesticides that you're mad about. Our pesticides weren't even available in 2015, 2016. So we've got these lawsuits going on. We have drift cases all around the country related to 2015 and 2016, and then also related to the new products once they came on the market. So everybody's mad about drift of these products. There was a case called Bader Farms versus Monsanto. This was from Missouri. This was not a class action. It was just a single plaintiff. It was a peach farm in Missouri that suffered pretty significant dicamba drift damage in 2015 and 2016. They sued Monsanto, got a verdict last year for $265 million. The majority of that was punitive damages. That's the damages like to punish Monsanto for their bad actions. So that case happened. Then there's what's called an MDL. It's a class action in multi-district litigation. Essentially, there are lawsuits filed on behalf of every farmer around the country who suffered drift damage during these times, and there's these lawsuits that are pending on those, all right? So that's going on. Then last June happens, okay? In June of 2020, the United States Court of Appeals for the Ninth Circuit vacated the registration for 3 of the products, right? Extendamax, Fexapan, and Ingenia. This couldn't have happened at a worse time in Texas, right? Because it was right in the middle of when we needed to be spraying them. All of a sudden, they didn't just say, we're not going to re-register it. They said, registration canceled, and everybody was in a panic because it was like, holy crap, what do we do now, right? And this is an example of, it's not just EPA we have to worry about. EPA didn't do this, right? A court did this. And it was kind of a environmental advocacy group that brought this lawsuit. You see what I'm saying? So it's not just, we got fights on every side is what I'm telling you. Okay? So this happens, panic ensues. The EPA eventually came out with an existing stock order that basically said if you already have the products, you can use your existing stocks through July of 2020. So that's what got everybody kind of through last year. And at that point, as of July 2020, there was no registration for these 3 products. Now, Tavium was still registered, the Syngenta product, because it wasn't part of the lawsuit. Okay? But none of that really mattered after July because the registration for all 4 of these expired in November of 2020. And that was the case even before the lawsuit. So I guess fortunately for those companies, they were already working on getting them re-registered in 2020. Okay? So those applications had been in. The EPA issued a decision in November that said, okay, we are going to re-register 3 of the products. Extendamax, Ingenia, and Tavium all get a 5-year registration from EPA. All right? So they're available through 2025, but they put in some new restrictions. The first thing they did is a nationwide cutoff date of July 30th. You cannot spray after July 30th if you're using these products. There's an increased buffer requirement about what buffer zone you need to have if you're going to apply. There's a required use of a buffering agent, and then there's a simplified label. That was one thing the court talked about, was the label was so complicated nobody could follow it. And so they tried to simplify the label and make that easier to understand. So that happened in November. So for this growing season, we've got it registered from now through 2025. Except that's not the end of the story, because once again, who's involved? The lawyers, right? So things go south again. We've got lawsuits on both sides of the new registration, which I think is interesting. The American Soybean Association and Plains Cotton Growers filed a lawsuit against the EPA saying that the new registration was too restrictive. They basically said, we don't like this nationwide cutoff date. That's too restrictive. The science doesn't support that. And they don't like the increased buffer. Again, they're saying the science doesn't support that. That should not be part of the registration. On the complete opposite side of the spectrum, we have a lawsuit from the National Family Farm Coalition, same group that filed last time and got it decertified in the Ninth Circuit. They say the law is not restrictive enough, right? They shouldn't have approved it at all, but if they were going to, there need to be even stricter guidelines. So all these lawsuits are currently pending. We'll have to see what happens with those. In January 2021, there was a little inauguration, right? And when there was an inauguration, what did that do at EPA? New people in charge, right? So we went from the Trump EPA, who approved this registration for the next 5 years, to the Biden EPA, who's in charge now. And then, listen, one more thing. In February, Corteva says it's not going to sell Fexapan anymore in the U.S. So Fexapan's out. You got your other three options that have their registration, okay? Then, about a week ago, a news story breaks, and there's some internal emails that a reporter got a hold of from the EPA, and it basically said that the registration decision in 2018 was made because of political pressure. It wasn't based on the science. EPA people were pressured to approve it. That's not ideal to be coming out from the EPA, but that happened. One thing that the new EPA administrator has said is that in his view, this needs to be re-looked at, but he thinks he wants to do it after the growing season. So fingers crossed, right? At least we get through the growing season. We don't have another situation in May or June where this gets yanked out. We'll see what happens. Just be aware there's still a lot of issues there from a legal standpoint. And again, we do have those two cases pending. The law moves too slow for that to be an issue, I think, this growing season. It would surprise me if something came up in 2021. Okay? So that's the legal backdrop of dicamba. The one other thing that's going on is there has been a settlement that was announced back in December for soybean growers. This is only for soybeans. And what it basically says is there's going to be a $400 million settlement that Bayer's going to pay, and they are going to pay it to soybean farmers who can document yield loss because of drift from 2015 to 2020. So I don't think we grow a lot of soybeans here. But for soybean growers, if you've got drift loss you can show because of dicamba drift, you can file a claim through May 28th. There are, like I said, there are still pending lawsuits related to drift for other crops, cotton, pecans, peaches, any other crops that are claiming dicamba drift damage. They haven't settled those yet. Those are still pending. So that's the legal situation where we are with dicamba. Okay, my last case has to do with a solar lease. And again, I think that this is sort of interesting from a legal, nerd standpoint. There's a case called Lyle versus Midway Solar. It just came out of the appellate court here in Texas. And essentially, here's the situation. There's 315 acres in Pecos County. Okay? Lyle, I think it was a couple, Mr. and Mrs. Lyle, own part of the mineral rights. I think they own 30% of the mineral rights to this 315 acres. Somebody named Drac owns the surface of the property, right? That's common, right? A lot of times we own the surface, we don't own the minerals, or don't own all of the minerals. So this happens a lot. Well, Drac enters into a solar lease with this company called Midway Solar. They're going to put a solar field on the property. Okay? Midway Solar tried to get waivers from the mineral owners. And you'll see this a lot. solar companies almost always are going to want you to either own all of the minerals, control all of the minerals, or they want a waiver from the mineral owners that basically says, we agree not to do anything on the surface of the land, right? And the reason for that is what they don't want to do. They don't want to build this big solar field, and then all of a sudden now we want to put a pump jack right in the middle of it. So they seek these surface waivers where the mineral owners basically say, we're not going to produce the mineral on the surface, or they'll set up these kind of drilling areas, and you'll see in a map in just a second. They'll set aside and say, okay, here's 50 acres. If you're going to drill, you drill on those 50. They want people to agree to that. In this case, the company tried to get those waivers, but somehow they screwed up who owned minerals for which tract, and they did not have waivers from the actual mineral owners for this 315 acres. They amended the lease to identify these designated drilling sites like I mentioned, and here's the map. So you'll see, right, the majority here we have in solar panels, but they left room at the top and they left room at the bottom for drilling. All right? So that's the setup. Then we have the mineral owner, Lyle, who's not happy. He files a lawsuit against the solar company and the surface owner, and he says that them building that solar field was a breach of his 1948 mineral lease because it denies him the right to use 70% of the surface of the land to produce the minerals. Now, that may seem like a weird argument to you, but you got to remember this. In Texas law, the mineral estate is the dominant estate. And what that means is the law says if you're a mineral owner, you have the right to use as much of the surface as is reasonably necessary to produce the mineral. So that's an automatic implied right from the law that this guy has. Okay, and he says by building this solar thing, you have infringed on my mineral rights. I'm filing this lawsuit. The court rules in favor of the surface owner and the solar company. It's an interesting opinion. So the first thing they say is the accommodation doctrine does apply when you've got a situation where there's an argument between a mineral owner and a surface owner. Let me just explain to you what the accommodation doctrine is. In oil and gas law, like I said, they have the automatic right to use the surface, right? The mineral owner can use it to produce the oil and gas. But the accommodation doctrine basically says if I have an existing surface use, they would substantially impair. And if I can't make my surface use any other way, but they could produce the mineral another way, they have to do that. So in other words, let's say I've got this existing surface use. I've got my solar facility all built. I can't move that somewhere else, right? Like this is the land I have. I've built a solar facility, but they could drill in one of those designated drilling areas. They could still produce the mineral. They have to accommodate that existing use. That's how that doctrine works. But here there was a problem for the mineral owner because he had never tried to produce the minerals. So basically what he was saying was, hey, you're going to prevent me from drilling an oil well, but he never tried to do it. So it wasn't like, here's where I tried and I couldn't, or here's the geophysics, whatever, information that tells me I need to drill in the middle and not in these designated areas. He didn't have that. And so what the court basically said was, you don't have a claim because you weren't damaged yet, essentially, right? Now, if he goes out and tries to drill and there's some reason they can't because of the solar panels, we're back, and I don't know what happens, right? We're going to see the answer to that. I'll guarantee you there'll be a case in the next few years that will tell us how we're going to balance these interests. But I think it's a good example of how different ownership interests, different leases, there can be problems and conflicts that arise, and we're seeing it now with solar. Okay, this case is going to be appealed to the Texas Supreme Court. We'll see if they take it or not, but they have said that they will appeal. So, okay, I'm going to give you a few honorable mentions. Caitlin, how much time do I have? 20 minutes? We can just talk all day. Okay, let's do this. Do y'all have questions before I jump into my next list of honorable mentions? Okay, let's just roll on then. One big issue, I've talked about this a million times here, the fight over the definition of waters of the United States under the Clean Water Act. That's still going on, and I think it just keeps getting worse. So the background, right, we've got the Clean Water Act, which is a federal law that gives the EPA and the U.S. Army Corps of Engineers jurisdiction over waters of the United States. So essentially, let's say I own a property. If part of that is a water of the United States, I have to get a permit before I can do certain things on that property. If I'm going to move dirt, I got to go get a permit from the U.S. Army Corps of Engineers to do that. So it's a big deal for a landowner to know, is it a water of the United States? Is it not? The problem is the statute says it applies to waters of the United States. It was passed in the 70s. What the statute didn't do was define what is a water of the United States. One would think that might have been an important thing to include. Apparently not, right? So we've had fights for the last 50 years over, is it a water of the U.S., is it not? A lot of the arguments are about adjacent wetlands, not an issue here, right? But places where there's water. If we've got a river and there are wetlands close to the river, are those wetlands considered a water of the United States? Lots of fights about that. What about a tributary to a river? So we all know the Mississippi River is a water of the United States, but what about a tributary that flows into the Mississippi? Is that a water of the United States? And what about a tributary of that tributary, right? How far back do we go? That's an issue. My favorite and the dumbest case on this issue was a gravel pit in Minnesota. So this guy owned this gravel pit. They wanted to start developing it. They want to start moving dirt. They get an enforcement letter from the Corps of Engineers, and they say, wait a minute, your gravel pits are waters of the United States. And the guy's like, what are you talking about? We're 8 miles from the closest river. They're just holes that fill up with water when it rains. And here was the theory of the Corps of Engineers at the time. The gravel pits, when there was water in them, ducks would land on them. Those ducks would fly across state lines and land in other waters. Therefore, they were interstate ducks. Okay? Those were interstate waters, and you had to get a permit from the EPA to move your dirt. The Supreme Court said, no. That went too far, okay? But that's an example of the kind of crap that can come up. Oh, I'm on the radio. I shouldn't say that. That's an example of what can happen, right, when you're dealing with these statutes, okay? So the definition battle continues. In 2015, the Obama administration put forth a definition of waters in the United States. Basically, they said, look, we got to clear this up. We're sick of all the lawsuits. We're going to write a definition to clarify what it means. Opponents of that would say the problem was it didn't really clarify, it expanded the definition. And it was pretty broad. And so there was a lot of concern that this broadened the scope where it could potentially affect ag landowners because it was written really broadly. So that happens when Obama's in office. Then we get Trump elected and we swing the other way, and Trump writes what's called the Navigable Waters Protection Rule, which is a new definition of waters of the United States that's quite a bit narrower. Okay? It doesn't include some of these tributaries of a tributary. Big one for us, it doesn't include intermittent streams. So if you've got a stream that only flows when there's water, or something maybe like apply a lake that only fills up when it rains, the Trump definition says those are out. So we have that. And we got lawsuits galore about all of these, right? But then the Biden administration comes in. And so now we're waiting to see what definition they're going to propose. And could it be the Obama definition again? Maybe. Will they write their own definition? Maybe. The one thing I'm sure of is we're going to have a bunch more lawsuits about it, right? And I guess the concern I have is we're going to just keep swinging on this pendulum every time we get a new administration in. The fix would be if Congress would pass a statute that defined waters of the United States. I think the odds of that happening probably are slim to none because Congress would have to agree and pass something. So for now, I think we're still in the back and forth. Right now, it's the Trump definition that's in play, the Navigable Waters Protection Rule. So there's that. Oh, this is a Texas one that's interesting. Does a high-speed rail have eminent domain authority? So you guys know, you've heard about the proposed high-speed rail that will go from Dallas to Houston, right? They'll connect them. It'll be built on this platform, etc. Well, to build that rail, the company, it's a Japanese company that's come in to put this in, they say we are going to have eminent domain power, right, to buy the land we need along the path of our rail, which is fine. If people agree, they just write an agreement, get paid, and go on. But we've got a lot of rural ag landowners who don't want this high-speed train coming through their farm, right? And they said, no, we're not selling you an easement to do this. And the high-speed rail has said, well, we don't really care if you're going to sell us an easement or not. We have eminent domain power, and we'll just condemn your land and build our train. So the question has come up, does this private high-speed rail company have eminent domain power? And there was a lawsuit that was filed, I think it was Leon County, and the landowner filed the lawsuit, and his argument was basically this. We've got a foreign company that doesn't own any train tracks and doesn't own any trains in America. We don't think that they are a railroad, okay, because we have a statute that says a railroad or an interurban railway has eminent domain power. The statute says that. But this landowner says, I don't think they're either one of those. They don't have any trains. They don't have any railroads. They're not one of these. We say they don't have the power to take our land. The trial court judge agreed with the landowners and said they don't have eminent domain power. They appealed that, and the appellate court said, yes, they do. The appellate court said, we do think that they're a railroad or an interurban railway. They don't have to own that stuff now. If their intent is to be one of those, they can take the land. That's been appealed to the Texas Supreme Court. We'll see what happens. They'll have to make a decision about whether or not this high-speed rail company can use eminent domain power. So keep an eye out for that. Legal issues related to hemp production. If you're looking to grow hemp, there's a lot of regulatory issues and legal issues you better be aware of. We actually just did a video series on this. We got a grant to work on some hemp stuff. It's like 3 hours of video. They broke them into little chunks because, 3 hours of me is a lot. But they broke them into considerations about hemp contracts. We talk about the USDA regulations, the TDA regulations. We've got stuff on crop insurance, some economic outlooks. So if you're looking at hemp, I would really encourage you to check that out. You can find it on my blog. I feel like the hemp craze has kind of gone by the wayside a lot, and I feel like there's a couple of reasons, right? Number one, from my perspective, a lot of these regulatory hoops are complicated. Number two, the price tanked, right? If you've looked at the price in the last year, it's fallen off crazy. And then number three, the price of other commodities has gone up, right? So I think all that played into, I don't know how many people are still looking at that, but if you are, do check out those videos we have if you're interested. There's been litigation about the beef checkoff. I don't know how many of y'all are cattle folks or if you have followed this. There's been a lawsuit up in Montana challenging the Montana beef checkoff. And the reason we care about that in Texas is ours is kind of set up the same way. And so it's really a constitutional First Amendment argument. So in Montana, when you sell cattle, right, you pay your $1 a head assessment. 50 cents goes to the National Beef Board. 50 cents goes to the Montana Cattlemen's Association, and that's their state checkoff. And right, they use it for things like promotion and research and the ads we see, beef is what's for dinner on TV. This group in Montana, RCAF, files a lawsuit against the Montana Beef Council and says, hey, we think you're violating our First Amendment rights. And the reason is the government is making us fund speech that we don't agree with. And we think it's private speech. Okay, so and there's a distinction here between public and private and how the law works. But basically what they say is all these ads that the Montana Beef Council keeps running are about beef generally. It's not about American beef. And we think we should only be promoting American beef, and we disagree with your ads, and the government is making us pay for private speech that we disagree with. So in the lawsuit, while this is going on, the Montana Beef Council and the Texas one and about 14 others enter into what's called a memorandum of understanding, an agreement with USDA that basically says USDA has oversight of all the advertisements that come out of the local beef councils. And the reason they did that is if USDA has oversight, it's public speech. It's not private speech, and this lawsuit gets dismissed. The First Amendment doesn't offer the same protections to public speech as it does private. So that happened. The lawsuit did get dismissed. They said it's public speech because of these MOUs. Well, now RCAF has filed a lawsuit against USDA and basically said, you entered into those MOUs illegally. You can't do it that way. You didn't follow all the things you have to follow. So that litigation is still ongoing. So that's another one just to watch and be aware of. There were some hog farm lawsuits in North Carolina that I think probably should be scary for everybody in agriculture, whether you raise pigs or not. What happened there is there are a bunch of like vertically integrated hog operations owned by Murphy Brown, okay, which is a subsidiary of Smithfield. And so they're all right, the individual farmer has the operation. They contract with Murphy Brown to raise these pigs. There's 26 of those farms in North Carolina that got sued for nuisance by their neighbors. And what happened was there was a lawyer from Texas, and I think there was a couple from North Carolina as well, but these lawyers went around and talked to all these neighbors and gathered up lawsuits against 26 of these farms, and the complaints were things like nuisance, odor, flies, loud noise, dust, okay? And they filed a lawsuit seeking an injunction to get these farms shut down. There's a law on the books in every state that theoretically should protect this type of situation. We have one here in Texas. It's called the Right to Farm Act. And what it basically says is an ag operation isn't liable for a nuisance. In Texas, it says, so long as that operation has been in place for at least a year. So, for example, right, let's say I got a pig farm. I'm operating for 10 years. My neighbor decides to sue me and complain about the smell. This statute should dismiss it, right? It's my defense against that claim. The problem was the North Carolina one wasn't written quite as well as the Texas one. The judge said it didn't apply, and these cases go forward. 5 of them went to trial, and they all resulted in like multi-million-dollar verdicts in favor of the plaintiffs. And so it was a real hit on the North Carolina pork industry. In a legal turn of events, they ended up on an appeal at the 4th Circuit. The plaintiffs won, and Smithfield announced that they were settling all those cases. And at most of those farms, there aren't pigs there anymore. So, again, I think just be aware of these issues are out there. There are plaintiffs' lawyers. There are plaintiffs that are going against ag, not only, right, like in legislation and stuff, but you see it in courts, lawsuits as well. This is also related to the Clean Water Act. There's a case, this was at the U.S. Supreme Court last year. Essentially, the Clean Water Act says if you're going to discharge a pollutant into a water of the United States, you got to have a permit. And this was designed, right, it happened back in the 70s, and there were some, like, in Ohio, there'd be a factory that would have a pipe out the back of the river that's, like, shooting junk into the river, and the river's catching on fire, right? So the Clean Water Act was like, well, that's a bad idea, so if you're going to be putting pollutants into a water of the U.S., you got to have a permit. The question has arisen, does it have to be a direct discharge into the water of the United States, or could it be indirect? So we know the pipe in the river that counts, okay? But this question was a little trickier because what happened in Hawaii, on the county of Maui, they have injection wells for like effluent, right? There's pollutants in the effluent. They inject them into the groundwater. Groundwater is not a water of the United States, but it travels through the groundwater and ends up in the Pacific Ocean. That is a water of the United States, okay? And so environmental group files a lawsuit against the county and says, hey, you got to have a permit for those injection wells. And the county says, no, we don't. We're not injecting it into a water of the U.S. We're injecting it into the groundwater, and it's not a direct discharge. So they end up at the U.S. Supreme Court an argument over, does this discharge have to be direct? And it was interesting. I happened to be in D.C., and I got to go watch the oral arguments of this case. And the justices, you could tell they really struggled with it because on the one hand, they basically said, look, any discharge could eventually be traced to a water of the United States, right? Justice Roberts said, what happens if somebody flushes their toilet in Colorado, it goes into the septic tank, and science is really good. What if they can trace that molecule to the, whatever, river, Canadian River? Well, crap, we can't have everybody with a septic tank having to get a Clean Water Act permit. So they didn't want to go too far, but then they also said, well, wait a minute. If you're saying, like, it's almost technicality like an in run around the act. So what if the pipe didn't go right into the river? What if they backed it up 10 feet and put it underground there? Now you're telling me that's not a discharge? Like, that seems to undo the purpose of the act. So they came up with this new test. And what they said was, you have to get a permit if it's a direct discharge or the functional equivalent of a direct discharge. The problem is, ain't nobody knows what is a functional equivalent, right? These are the kind of words that create lawsuits because they're mushy. And the court said, well, there's all these factors you can consider. It gave them 8 factors, but said that's not really an exclusive list and da-da-da. So we're going to have to wait and see how that shakes out, what cases tell us the law means. Here's, to me, where this could be a little bit concerning, right? I mean, I don't really care about the injection wells in Hawaii, but could this affect ag? What if it's a lagoon, and the lagoon leaks into the groundwater, and they can prove that ends up somewhere? That's a little more concerning to me, right? So I think that there's a reason to be interested here. We'll see how those cases shake out a little bit. This is the last thing I'll mention because it's been in the news a little bit. Are there going to be changes to federal tax laws that could affect us? 2 in particular you sort of hear about. One of them is the estate tax. Okay? Now, just so everybody's clear, the estate tax is a federal level tax, right? IRS tax that you pay when you die to pass your assets to somebody else. Right now, you have what's called an exemption. If the value of your estate is below the exemption, you don't pay any money. Right now, the exemption is $11 million per person. So for most of us, unfortunately, it's not really a problem, right? So my husband and I each have $11 million. Our estate is not worth $22 million. I ain't paying no tax. Here's where it gets concerning, though. They could change, Congress could change that exemption amount. It used to be $5 million. Still too high for me. Okay? 20 years ago, it was $1 million. Now, that's starting to be a problem, right? You think about, if you're farming, if you own any land and one of those stripper balers, right, that's $1 million in assets. And now when you die, you could owe the estate tax. And does anybody know what the tax rate is for the estate tax? 40%. 40. It's no joke, right? You don't want to have to do this. So they could do away with the estate tax altogether. I don't see that happening. I think our bigger concern right now is that exemption needs to stay high enough where most of us don't have to deal with it. If that exemption were to move lower, it could be a real issue for people. Now, there's things you can do to avoid estate tax liability, but you've got to do it, right? And that's estate planning stuff. You might have to look at trusts or gifting or LLCs. You got to talk to an accountant and a lawyer about that stuff. But just be aware, if that exemption were to change, that could be a problem. Okay? The other thing that we've heard in the news as well has to do with the step up in basis for capital gains taxes. So capital gains taxes, if you buy an asset or get an asset and it increases in value over time and you sell it, you got to pay a capital gains tax on the income. Okay, so for example, this time last year when the stock market kind of crashed, I bought Southwest Airlines stock, right? Because I'm telling you, I keep them in business, right? So I buy Southwest Airlines stock, and let's say it costs $20 a share. Well, now it's worth $60 a share. If I sell that stock, I pay capital gains taxes on $40, all right? Not that big of a deal about a stock. I got to pay my tax. Where it can be a real problem is on land, right? Especially generational land. So think about my grandma bought our farm, and she paid $50 an acre in the 60s. Now, let's say it's worth $6.50 an acre. I'm in New Mexico. I'm not over here with you expensive people, okay? Now, $6.50 an acre. If we sell the land, we're paying capital gains tax on $600, right? And way higher in other places, right? Think about Iowa. What if they bought it at $50 an acre and now it's worth $12,000 an acre? Our capital gains taxes are huge. But there's something in the law right now called a step up in basis that can be helpful, again, especially to intergenerational transfers. What that says is if the asset is transferred at the person's death, the person getting it gets a step up in basis to the value at that time. So let's say my grandma buys the land for $50 an acre. When she died, let's say it was worth $500. If I inherited that under her will, I get to step the basis up to $500. And now if I sell the land, I only pay on the $150 difference. Does that make sense? So that step up in basis can be really important. And again, it only comes into play when you sell the land. So that limits it a little bit. But under the Biden tax plan, at least what's on his website, there's some talk about doing away with the step up in basis altogether, where that wouldn't be an option anymore. So again, be aware of it. It hasn't happened yet. It's just been on, I think, everybody's radar since it's been on his website. So be aware of that. The last slide here is my contact info. This is basically my business card. So if y'all have any questions, if you want any of the information that I mentioned, there's my info. Feel free to reach out. I'm going to stick around for lunch, so I'm glad to visit with you then as well.